Generally, absent an explicit agreement to the contrary, a promoter, or person who takes steps to form an entity, such as a corporation, is personally liable for contracts entered into on behalf of a yet-to-be-formed entity. But what happens when the entity is formed? Is a promoter still personally liable for contracts entered into on its behalf after formation? The Pennsylvania Supreme Court considered this question in RKO-Stanley Warner Theaters versus Graziano. Ralph Graziano and Jack Jenofsky were promoters for the yet-to-be-formed Pennsylvania corporation Kent Enterprises. In April of 1970, Graziano and Jenofsky, on behalf of Kent Enterprises, contracted to purchase the Kent Theater building in Philadelphia from RKO-Stanley Warner Theaters. Under the contract, the parties stated that Graziano and Jenofsky intended to incorporate Kent Enterprises. Further, the contract provided that as long as they incorporated before closing, the contract would be construed to have been made between RKO and Kent Enterprises. Subsequently, when Graziano and Jenofsky failed to complete the sale by the closing date, RKO sued them individually in the Court of Common Pleas based on equity, seeking judicial enforcement of the contract. In response, the men claimed they weren't personally liable. Following a hearing, the court entered judgment in favor of RKO. Graziano and Jenofsky appealed to the Pennsylvania Supreme Court.